Number 1. Noah Crooks, the boy who thought he'd get grounded. There are moments in the study of criminal behavior that leave even the most seasoned investigators and psychologists struggling to find adequate words. Moments where the evidence before them defies the very assumptions society holds most dear about childhood innocence, about the sanctity of the parent-child bond, and about the capacity of a young mind to understand the weight of permanent, irreversible action. And the case of Noah Riley Crooks is one such moment, unfolding on a cold evening. In March of 2012 in the small rural community of Osage, Iowa, a town of fewer than 4,000 people nestled in Mitchell County, a place where neighbors knew each other by name, where front doors were sometimes left unlocked, and where the kind of tragedy that would come to define that particular evening had no real precedent in the community's living memory. A community that would find itself completely unprepared for the news that would emerge from a modest family home on the outskirts of town. News that would travel far beyond the borders of Mitchell County and eventually reach courtrooms, psychology journals, and true crime discussions across the country, because what happened inside that home on the night of March 24, 2012, was not simply a crime. It was a window into a category of human behavior that challenges every comfortable assumption we hold about the relationship between a parent and a child. Gretchen Crooks was 37 years old at the time of her death, a registered nurse employed at Mercy Hospital in Mason City, Iowa. A demanding profession she carried out with dedication and compassion, and she was simultaneously pursuing her master's degree at the University of Iowa, balancing the weight of a full-time medical career with the ambitions of advanced academic study. Doing so while raising her son Noah and maintaining a household in rural Osage alongside her husband William Crooks, who worked at Cargill Kitchen Solutions in Mason City and who had been married to Gretchen for 17 years by the time the events of that March evening occurred. And by every account that investigators, neighbors, colleagues, and family members would later give, the Crooks household was a stable, grounded, working-class Midwestern family. Not wealthy, not troubled in any visible or documented way. Simply a family living the kind of quiet, industrious life that defines the social fabric of small-town Iowa. A life built on work and commitment and the ordinary rhythms of raising a child and building a future together. Noah, their only child, was 13 years old and an 8th grader at Osage Middle School at the time of the crime, and he had no prior criminal record of any kind. No teacher had flagged him as a child of particular concern. No school counselor had raised formal alarms about his behavior or his emotional state. No neighbor had reported anything unusual about his conduct. And by every external and observable measure, he appeared to be an ordinary young teenager navigating the ordinary social and academic landscape of early adolescence in a small Midwestern town, which is precisely what makes the events of that evening so profoundly difficult to process and so deeply unsettling to examine. Because the violence that Noah Crooks brought into his own home on the night of March 24, 2012, did not emerge from a background of documented trauma, documented abuse, or any of the conventional environmental factors that society often reaches for when trying to explain why a child commits an act of catastrophic violence. On that evening, William Crooks was away from home attending a work-related social event connected to his position at Cargill, leaving Gretchen alone in the house with their son, and at some point during the course of that evening Gretchen made a parenting decision that was, by any reasonable and objective standard, entirely ordinary. The kind of decision that parents across the country make every single day without a moment's hesitation or anxiety. She took away Noah's video games, whether because he had failed to complete schoolwork, had violated a household rule, or had simply been spending too much time in front of a screen. The precise triggering circumstances of that specific decision are less important than what came next, because what came next was not an argument, not a sulk, not a teenager retreating to his room in frustration the way that teenagers across the world do every single day. What came next was Noah Crooks going upstairs, locating a .22 caliber rifle, loading that rifle with deliberate and purposeful action, carrying it back downstairs, finding his mother in the kitchen with her back turned to him, and opening fire, shooting Gretchen Crooks 22 times, a number so staggering in its repetition that it speaks not to a moment of sudden explosive impulse, but to something far more sustained, far more deliberate. and far more chilling in its implications about the emotional and psychological state of the child pulling the trigger. And when the shooting was over and Gretchen Crooks lay dying in her own kitchen in the home she had built and maintained for her family, Noah Crooks did not flee, did not break down, did not call for help in any urgent or panicked way that might suggest the overwhelming shock and horror that any child who had just experienced such a moment, even as its perpetrator, might reasonably be expected to display. Instead, he called 911 and reported the shooting and the concerns he expressed during that call, as would later be documented in the legal record, were not primarily about his mother's survival or about the gravity of what he had done, but rather about what was going to happen to him, a detail that investigators and psychologists would later point to as one of the earliest and most revealing indicators of the profound emotional and psychological disorder that defined Noah Crooks's inner world. When his father William returned home and later met with Noah in the presence of counselors in an attempt to understand what had happened and why, Noah's response to questions about the killing was, according to court records, that he thought they would be better off without her, a statement so cold, so disconnected from any recognizable framework of grief or remorse, that it would haunt the proceedings of every subsequent legal hearing and would eventually be cited directly by the Iowa Supreme Court in its written opinion on the case. The state of Iowa filed a delinquency petition against Noah just 4 days after the shooting, alleging that the 13-year-old had committed the delinquent acts of first-degree murder and assault with intent to commit sexual abuse. The latter charge related to additional conduct alleged by prosecutors in connection with the events of that evening, and the juvenile court, after careful consideration of the severity of the crime and the legal standards governing cases of this nature, made the significant decision to waive its jurisdiction over Noah and transfer the case to district court for prosecution as a youthful offender in adult court, a decision that would itself become a subject of legal challenge in the years that followed, but that was upheld at every level of review. Reflecting the court system's assessment that the gravity of what Noah had done placed this case in a category that the juvenile justice system alone was not equipped to adequately address. The jury trial began on April 30th, 2013, with Noah now 14 years old and represented by defense attorneys who raised the defenses of insanity and diminished responsibility, arguing that whatever had driven their client to commit this act was rooted in a psychological condition that undermined his capacity for the kind of rational, purposeful decision-making that the law requires for a finding of first-degree murder. And on May 13, 2013, after more than 18 hours of deliberations, the jury returned its verdict, guilty of murder in the second degree, and not guilty on the charge of assault with intent to commit sexual abuse, a verdict that represented a finding that Noah had caused his mother's death without the specific premeditation required for a first-degree conviction, but with the full awareness and intention that defines second-degree murder under Iowa law. Because Noah was convicted as a youthful offender, the court initially ordered a deferred sentence and placed him at the Eldora State Training School for Boys, a juvenile correctional facility in Iowa, where he would remain until he turned 18, at which point he would return to district court to face sentencing as an adult, a legal framework that gave the court system approximately 5 years to observe Noah's progress, his behavior, his engagement with treatment and rehabilitation programming, and his overall trajectory before making a final determination about the length of his adult prison sentence. And what those 5 years revealed was, by the account of those who worked with him and those who evaluated him, deeply troubling. Noah Crooks spent those years at Eldora almost entirely unwilling to discuss his mother, unwilling to engage meaningfully with the reasons behind what he had done, unwilling to demonstrate the kind of genuine reflection and remorse that rehabilitation requires as its foundation. And when his father William visited him repeatedly during those years and pushed him, directly, painfully, with the love and anguish of a man who had lost his wife and was now watching his son's future disappear, to talk about Gretchen, to acknowledge her, to grieve her, Noah consistently refused. A refusal that William Crooks would describe in heartbreaking terms at the May 2016 sentencing hearing when he stood before the court and addressed his son directly, telling Noah that in 4 years of visits he had never once spoken about his mother, that he had shown no remorse, and that 4 years was not enough to pay for taking her life, and that while he loved his son, To let him out would ruin so many more lives. Words delivered not in anger, but in the quiet devastation of a father who had spent 4 years hoping that somewhere inside his son there was a capacity for genuine human feeling that would eventually find its way to the surface, and who had arrived at the conclusion, painful beyond measure, that it had not. In May of 2016, when Noah Crooks turned 18, Kosciuszko County District Court judge sentenced him to 50 years in prison, a sentence that immediately became the subject of an appeal in which Noah's attorneys argued that the case should not have been prosecuted under the youthful offender statutes, that the juvenile court should have retained jurisdiction, and that a 50-year prison sentence imposed on someone who had been 13 years old at the time of the crime constituted cruel and unusual punishment in violation of constitutional protections, arguments that were heard and carefully considered by the Iowa Supreme Court, which in April of 2018 issued its written opinion affirming both the conviction and the sentence, finding that the district court had properly exercised its discretion based on an individualized assessment of Noah Crooks as a defendant, noting that the psychologist who examined him in 2012 had concluded that he was not capable of experiencing guilt or remorse, noting that his own father had described 5 years of visits without a single meaningful conversation about the mother he had killed, noting that a psychological profile characterized by deeply ingrained personality traits that were present well before the crime and that no known treatment could address. All of these factors combining to support the sentencing court's conclusion that 50 years, with immediate parole eligibility, was a constitutionally permissible and individually appropriate response to the crime that Noah Crooks had committed. As of the time of this research, Noah Crooks remains incarcerated in the Iowa State prison system, serving out a sentence that reflects not only the legal system's judgment about the severity of what he did on the evening of March 24, 2012, but also its judgment about the kind of person he demonstrated himself to be in the years that followed, a person who, when asked by his own father why he had killed his mother, said that he thought he would maybe get grounded, a statement so disconnected from any proportionate understanding of human life and consequence that it has become, in the years since, perhaps the single most chilling sentence associated with this entire case, a sentence that captures in 8 words the vast and terrifying gulf between the interior world of Noah Crooks and the world of ordinary human feeling, ordinary human empathy, and ordinary human love that Gretchen Crooks had given everything she had to provide for the son who took her life over a video game. Number 2. Donovan Nicholas, the boy with 2 faces. There are criminal cases that force the legal system to confront questions it was never entirely designed to answer. Questions that sit at the intersection of law, medicine, psychology, and the deepest philosophical puzzles about identity, responsibility, and what it means to hold a person accountable for actions they claim were committed by someone else living inside them. In the case of Donovan A. Nicholas is precisely that kind of case, a case that began in a modest home in Mad River Township in Champaign County, Ohio, on the afternoon of April 6, 2017, and that would eventually travel all the way to the Supreme Court of Ohio, generating a 4-3 split decision that divided the court's justices, sparked fierce public debate about juvenile justice and the treatment of mentally ill young offenders, and ultimately resulted in one of the most extraordinary legal outcomes in the recent history of Ohio criminal proceedings, an outcome in which a young man who had been convicted of aggravated murder and sentenced to life in prison walked out of custody at the age of 21 after the state's highest court concluded that the juvenile court had made a fundamental error in how it handled his case from the very beginning. Donovan Nicholas was 14 years old in April of 2017, a student at Graham Middle School in Champaign County, and he lived in a household on Valley Pike in Mad River Township with his father and his father's live-in girlfriend, a 40-year-old woman named Heidi Faye Taylor, a woman whom Donovan had grown up calling Mom, a woman who had been a consistent presence in the household and who, by the accounts of those who knew her, had invested genuine emotional energy in her relationship with Donovan and with the family she had helped to build alongside his father. Heidi Taylor was, in every meaningful sense, a maternal figure in Donovan's daily life. Not his biological mother, but a woman who had taken on the role of a parent, who had set rules and expectations in the household the way that parents do, who had cared for Donovan and disciplined him and been present in his life in the way that a parent is present. And it was precisely this relationship, this bond of trust and care and domestic familiarity, that makes what happened on the afternoon of April 6, 2017, so profoundly devastating to examine. On that afternoon, Heidi Taylor made a parenting decision that was, once again, and in the most ordinary possible sense, entirely routine. She took away Donovan's cell phone, a disciplinary measure that any parent might impose on a teenager for any number of reasons, a measure that in the overwhelming majority of households produces frustration, perhaps an argument, perhaps a period of sulking, and then a gradual return to the normal rhythms of family life. In Donovan Nicholas's household on that particular afternoon, it produced something that no one in that house, and no one who knew that family, could possibly have anticipated. According to the evidence presented at trial and the detailed accounts that emerged through the investigation and legal proceedings, Donovan came home from school that day and took a nap. And when he woke, something had shifted, something that he would later describe to investigators and to a 911 dispatcher in terms so unusual, so psychologically loaded, and so difficult to evaluate through any conventional lens that they became the central and most contested element of the entire case. When Donovan woke from his nap, he told investigators he was no longer entirely himself. He was, or had become, or had been taken over by, a second personality he called Jeff, a persona he had constructed and named after a fictional internet horror character known as Jeff the Killer, and it was this persona, Donovan would claim, that had committed what came next, not Donovan himself, not the 14-year-old boy who went to Graham Middle School, but Jeff, a separate identity, a separate consciousness, a separate entity who lived inside Donovan and over whom Donovan claimed to have no control. Before approaching Heidi Taylor, Donovan, or Jeff, as he would describe it, carved an exaggerated upward smile into his own face using a lancet needle, mimicking the appearance of the Jeff the Killer character, and then he went to find Heidi in the home. What followed was an attack of extraordinary and prolonged ferocity. Donovan approached Heidi Taylor from behind, embracing her before launching into a sustained assault that involved a knife, stabbing her repeatedly in a manner that investigators would later describe as involving more than 60 individual wounds, and when Heidi attempted to escape, running from the room in a desperate effort to reach safety, Donovan pursued her through the house, chasing her down the hallway before locating a firearm from a nightstand in the bedroom and using it to shoot Heidi Taylor in the temple, ending her life in the home she had shared with Donovan's father, in the home where she had tried to be a mother to a boy who would take everything from her. When Donovan called 911 after the attack, his explanation to the dispatcher was direct and, from a prosecutorial standpoint, extraordinarily significant. He told the operator that a person named Jeff, who he stated lives inside him, had killed her, establishing from the very first moments after the crime the narrative of dissociative identity disorder, an alternate personality that would become the foundation of his legal defense throughout every subsequent stage of the proceedings. Law enforcement arrested Donovan Nicholas, and the Champaign County Juvenile Court, after evaluating the circumstances and the severity of the crime, made the decision to transfer the case to adult court, a decision that would later become the central point of contention in the Ohio Supreme Court's review of the entire matter. In adult court, following a trial in which a jury heard extensive evidence about the attack itself, about the 911 call, about Donovan's claimed alternate personality, and about the competing assessments of mental health professionals regarding the validity and clinical significance of his dissociative claims, Donovan Nicholas was found guilty of aggravated murder and murder on July 18, 2018, and sentenced to life in prison with parole eligibility after 25 years, a sentence that reflected the jury's conclusion that whatever the psychological complexities of the case, Donovan Nicholas bore legal responsibility for the death of Heidi Faye Taylor. The case then entered a lengthy appeals process during which Donovan's attorneys challenged the decision to transfer the case from juvenile court to adult court, arguing that the juvenile court had mischaracterized expert testimony and had abused its discretion in concluding that Donovan was not amenable to rehabilitation within the juvenile system. Arguments that were rejected by the Second District Court of Appeals, but that ultimately prevailed before the Supreme Court of Ohio, which in December of 2022 issued a 4-3 decision vacating Donovan's conviction and ordering the case returned to Champaign County Juvenile Court, with the majority finding that the juvenile court's original transfer decision had been based on a mischaracterization of the testimony of a court-appointed psychologist and an Ohio Department of Youth Services representative, a conclusion that drew a sharp dissent from Justice Sharon Kennedy, who argued that the majority had engaged in judicial overreach by addressing an issue that was not properly before the court. The practical result of the Supreme Court's ruling was that Donovan Nicholas, who had entered the adult prison system as a teenager convicted of aggravated murder, was released from custody in July of 2023 at the age of 21, his conviction vacated and his case returned to a juvenile system that no longer had meaningful jurisdiction over him given his age. A legal outcome that left the family of Heidi Faye Taylor devastated and that reignited the broader public debate about how the justice system should balance the legal rights of young offenders with the demands of accountability for the most serious crimes, a debate that Heidi Taylor's daughter, Alyssa Nicholas, who had once called Donovan her brother, had addressed in heartbreaking terms at the original sentencing hearing, describing her mother as an extraordinary woman, describing the loss as a hole that could never be filled, and describing the experience of having the person she had trusted to watch over the people she loved become the person who took her mother away from her forever. Number 3. Antonio AJ Armstrong Jr. 3 trials, 1 verdict. There are criminal cases that seem, from the outside, to resist resolution. Cases where the evidence is contested, where the community is divided, where 2 trials end in hung juries, and the question of guilt becomes a years-long ordeal that exhausts everyone it touches. And the case of Antonio Armstrong Jr., known to nearly everyone who followed it as AJ, is precisely that kind of case. A case that began on the night of July 29, 2016, in a townhome in the Bel Air neighborhood of Southwest Houston, Texas, and that would not reach its final legal resolution until August of 2023, 7 years later, after 3 separate trials, 2 mistrials caused by juries unable to reach unanimous verdicts, and a legal journey that generated national media attention, divided the Armstrong family, and raised questions about evidence, DNA, and the reliability of the criminal justice process that remain a subject of passionate debate among those who believe in AJ Armstrong's guilt and those who remain equally passionate in their belief in his innocence. Antonio Armstrong Sr. was a man of considerable public profile in the Houston community, a former NFL linebacker who had played for the Miami Dolphins in 1995 and had subsequently played in the Canadian Football League, a man who after his professional football career had devoted himself to faith, family, and community, running a fitness and faith-based ministry with his wife Dawn Armstrong and raising 3 children in a household that those who knew it described as structured, principled, and deeply rooted in Christian values, a household where expectations were high and where the Armstrong children, including their 16-year-old son Antonio Jr., were held to standards of academic performance, personal conduct, and moral behavior that reflected the values Antonio Sr. and Dawn had chosen to build their lives and their family around. Dawn Armstrong, 42 years old at the time of her death, was by every account an equal partner in both the ministry and the household, a woman described by friends, colleagues, and community members as warm, devoted, and deeply committed to her children's futures. And it was this commitment, this insistence on holding their son to the standards they believed in, that would become, according to prosecutors, the motive that drove AJ Armstrong to commit an act that shattered the family he had grown up in and devastated a community that had looked up to his parents as examples of faith and purpose. In the weeks and months leading up to the night of July 29, 2016, the relationship between AJ Armstrong and his parents had been under significant strain. He had been expelled from the private school he attended, his grades had been failing, and he had been caught smoking marijuana, all of which had produced serious conflict within the household and had placed him, in the assessments of those around him, in a position of escalating tension with parents who were unwilling to lower their expectations or overlook conduct they considered unacceptable. On the night of July 29, 2016, Antonio Armstrong Sr. and Dawn Armstrong went to bed in their Southwest Houston home, and in the early hours of the following morning, At approximately 1:40 in the morning, their 16-year-old son Antonio Jr. called 911 from what he described as a hiding place in a closet, telling the emergency operator that he had heard shots coming from his parents' bedroom, that he was scared, and that his 12-year-old sister Kyra was elsewhere in the house. And responding officers arrived within minutes to find a scene of devastating violence. Antonio Armstrong Sr. had been shot once in the head, and Don Armstrong had been shot twice in the head, with pillows placed over both of their faces, and both had been shot at extremely close range in what investigators would describe as an execution-style attack carried out while they slept. And a .22 caliber pistol was found on a kitchen counter along with a handwritten note reading, "I have been watching you for a long time. Come get me." A note that prosecutors would later argue was a deliberate attempt by AJ to create the appearance of an intruder or a stalker, framing the murders as the work of someone from outside the family. And it was the inconsistencies in AJ's own account, combined with the physical evidence at the scene and the data from the home's alarm system, that led investigators to focus their attention on him almost immediately after their arrival. Antonio Armstrong Jr. was arrested in the hours following the discovery of his parents' bodies and charged with capital murder, a charge that in Texas, for a defendant who was a minor at the time of the crime, carried the possibility of life in prison with parole eligibility rather than the death penalty, and he maintained from the outset, publicly and consistently, and with the support of a significant portion of the Armstrong extended family, that he was innocent, that he had not killed his parents, and that the evidence against him had been mishandled or fabricated, a claim that gained particular traction when a forensic analyst employed by the prosecution was later fired for what was described as shoddy work. And that was supported by defense attorneys who argued at various stages of the proceedings that DNA evidence had been planted by Houston Police Department officers on AJ's clothing at the time of his arrest. The first trial began in April of 2019 and ended in a mistrial when the jury was unable to reach a unanimous verdict. The second trial, delayed multiple times by various procedural and pandemic-related factors, concluded in October of 2022 with another mistrial after 18 hours of jury deliberation produced no unanimous agreement. The third trial, which took place in August of 2023, featured extensive presentation of the evidence that prosecutors had been building and refining across all three proceedings. The home alarm system data, which prosecutors argued was inconsistent with AJ's account of events. Text messages between AJ and his parents that illustrated the volatile nature of their relationship in the days leading up to the killings. Evidence that AJ had fired the murder weapon into a pillow and a blanket inside his own bedroom. Evidence that he had lit a fire outside his parents' bedroom door 2 nights before the killings in what prosecutors characterized as a rehearsal or a test run. New DNA analysis, and the overall circumstantial architecture of a case built on the premise that no intruder had entered the Armstrong home that night, and that the only person with both the motive and the opportunity to commit the murders was the teenage son who called 911 from a closet and claimed he had heard shots. He did not fire. The jury in the third trial deliberated for approximately 10 hours before returning a verdict of guilty on the charge of capital murder, and AJ Armstrong, now 23 years old, was sentenced to life in prison with parole eligibility after 40 years, a sentence that means he will be in his 60s before he is eligible to be considered for release. And that was received in the courtroom with tears from his wife Kate, and with the quiet resolve of a legal team that immediately signaled its intention to continue fighting the conviction through the appeals process, while District Attorney Kim Ogg stated publicly that the community had found him guilty and that the Armstrong family, meaning Antonio Sr. and Dawn, had died because they were trying to be good parents, because they wanted their children to do right. Words that encapsulate the prosecution's narrative of this case, and that will continue to be contested by those who believe that AJ Armstrong's 7-year legal odyssey was not the story of a guilty man finally brought to justice, but of an innocent one ground down by a system determined to reach a particular outcome. Number 4. Sidney Powell, the secret that became a tragedy. There is a particular kind of pressure that builds in silence. The pressure of a secret carried alone, of a failure hidden from the people whose expectations feel impossible to meet, of a lie maintained day after day with the knowledge that its eventual discovery will bring consequences that feel in the distorted emotional landscape of a person in psychological crisis, too enormous to face. And it is within this framework of accumulated silence, hidden shame, and catastrophic emotional collapse that the case of Sidney Powell must be understood, not as a story of evil in the straightforward sense that the word is sometimes applied to cases of this nature, but as a story of what happens when severe, untreated mental illness collides with the unbearable weight of family expectation, producing an outcome so violent and so tragic that it defies easy categorization and has continued to generate legal controversy, medical debate, and profound disagreement about the nature of criminal responsibility long after the events themselves occurred. Sidney Powell was 19 years old in March of 2020, a young woman living with her parents in Akron, Ohio, and she had, for a period of months leading up to the events of March 3, 2020, been carrying a secret of significant weight. She had been expelled from the University of Mount Union, the college she was attending, due to poor academic performance, and she had chosen not to tell her parents, instead maintaining the appearance of a college student in good standing while the reality of her academic failure accumulated behind a wall of silence that she could not bring herself to dismantle. Her mother, Brenda Powell, was 50 years old and had spent nearly 30 years of her professional life as a child life specialist at Akron Children's Hospital, a role that involved supporting children and families through medical crises, a role that speaks volumes about the kind of person Brenda Powell was. Someone who had devoted decades of her working life to providing comfort and care to children in their most vulnerable moments. Someone whose professional colleagues would later describe her as a woman of extraordinary compassion and dedication. Someone whose death would leave a void in her workplace, in her community, and in the lives of everyone who had known her. Sidney's father, Steve Powell, and her maternal grandmother, Betsy Brown, would both later tell prosecutors and the court that they had urged the criminal justice system not to pursue a trial, that they believed Sidney needed treatment rather than prosecution, and that in their view the events of March 3, 2020, were the product of a severe and untreated mental illness rather than of criminal intent in any meaningful legal sense, a position that was shared by multiple medical professionals who evaluated Sidney, and that became the foundation of the defense strategy throughout the legal proceedings. On the morning of March 3, 2020, the secret that Sidney had been carrying for months finally broke open. Brenda Powell had learned the truth about her daughter's expulsion from the University of Mount Union, and she was on the telephone with school officials, discussing the situation, when Sidney entered the room and the confrontation that the defense would characterize as a psychotic break and that the prosecution would characterize as a premeditated and violent act began. Sidney struck her mother in the head with a cast-iron skillet, a blow of significant force delivered while Brenda was still on the phone with school officials, and then went to the kitchen, retrieved a steak knife, and stabbed her mother more than 23 times in the neck, a number that prosecutors emphasized throughout the trial as evidence of sustained and purposeful violence rather than the explosive and uncontrolled behavior of a person entirely disconnected from reality. While defense attorneys countered that the very ferocity and irrationality of the attack was itself evidence of a psychotic state in which Sidney had no meaningful awareness of what she was doing or any capacity to evaluate the wrongfulness of her actions. After the attack, Sidney staged a false scene intended to suggest that an intruder had entered the home and attacked her mother. She broke a window and told investigators that someone had come in from outside, and it was this act of evidence tampering that prosecutors pointed to as one of the clearest indicators that Sidney had retained enough awareness and enough rational thought during and after the attack to attempt to cover up what she had done, an argument that the defense disputed by pointing out that people experiencing severe psychotic episodes can engage in apparently purposeful behavior without any genuine awareness of its significance or meaning. The subsequent legal proceedings were dominated by what became an extensive and deeply contested battle of expert witnesses. Sidney's defense team called 3 mental health experts who testified that she had been suffering from severe, untreated schizophrenia at the time of the attack and was in the midst of a full psychotic break, entirely disconnected from reality and entirely unable to appreciate the wrongfulness of her actions, while the prosecution called a 4th expert who testified that Sidney was not legally insane at the time of the crime, that her actions before, during, and after the attack reflected sufficient awareness and purposeful decision-making to support a finding of criminal responsibility. And it was this battle of the experts that the jury was ultimately asked to resolve when they deliberated in the Summit County Common Pleas Court in September of 2023 and returned a verdict of guilty on charges of murder, felonious assault, and tampering with evidence. A verdict that Sydney's attorney Don Malarsic described in emotional terms after the verdict was read, saying that in his view this was not justice, that his client was a deeply ill young woman who needed treatment rather than a prison cell. Judge Kelly McLaughlin sentenced Sydney Powell to 15 years to life, the minimum sentence available, a decision that reflected, in the judge's discretion, some recognition of the mitigating circumstances presented by Sydney's mental health history, and Sydney Powell, now 23 years old, was taken into custody with parole eligibility set for 2038. The case did not end there. However, Sydney's legal team immediately appealed the conviction, and in 2025 the 9th District Court of Appeals of Ohio granted Sydney a new trial, finding that the trial court had committed a reversible error by refusing to allow the defense to present a surrebuttal case after the prosecution's final expert had testified, a ruling that the state of Ohio then appealed to the Ohio Supreme Court, which as of the time of this research was actively reviewing the question of whether Sydney Powell's conviction should be reinstated or whether the appeals court's grant of a new trial should stand, leaving the ultimate legal resolution of this deeply painful case still unresolved, still contested, and still generating profound disagreement about the nature of criminal responsibility, the treatment of severe mental illness within the criminal justice system, and what justice truly looks like when a tragedy of this magnitude unfolds at the intersection of family love, hidden shame, and a mind in catastrophic crisis. Number 5. David Ludwig, the boy who chose the worst possible answer. There are moments of confrontation between parents and the young men their daughters bring home that are, in the broad landscape of family life, entirely ordinary. Moments of concern, of boundary setting, of parental authority being exercised in the way that parents have exercised it since the beginning of family life itself. Moments that produce discomfort, perhaps anger, perhaps tears, but that resolve themselves through conversation and time and the gradual renegotiation of boundaries that adolescence always requires. And the confrontation that took place in the Borden family home in Warwick Township, Lancaster County, Pennsylvania, on the morning of November 13, 2005, began as precisely that kind of moment. A father, exercising his parental authority, telling a young man that he was no longer welcome to pursue a relationship with his teenage daughter, and ended as something that no one in that room could have anticipated, something that turned a moment of ordinary family friction into a crime that would cost 2 people their lives, send an 18-year-old man to prison for the rest of his life, and leave a 14-year-old girl without her parents, orphaned in an instant by the actions of the boy she had thought she loved. David G. Ludwig was 18 years old in November of 2005, and he had been in a secret relationship with 14-year-old Kara Borden, a relationship that both teenagers had worked to conceal from Kara's parents, Michael and Catherine Borden, who had already expressed their disapproval of the age gap between them and their discomfort with the nature of the relationship. And the concealment had involved the kind of deception that teenagers sometimes engage in when they believe their feelings are more important than the rules and boundaries their parents have established, lying about whereabouts, covering for each other, maintaining a version of their lives for their parents that did not reflect the reality of what was happening between them. The night before the killings, Kara and David had spent the night together without her parents' knowledge, and when Kara returned home the following morning, November 13, 2005, her parents discovered what had happened, and the confrontation that followed was, by any reasonable account, the response of parents who had been deceived and who were determined to protect their 14-year-old daughter from a relationship they viewed as inappropriate and potentially harmful. Kara called David and told him what had happened, and David, rather than accepting the consequences of a situation that, uncomfortable as it might have been, was fundamentally the kind of parental intervention that exists to protect young people, returned to the Borden home, and according to investigators, he did so carrying 2 guns and a hunting knife. A detail that speaks to something in his state of mind that goes far beyond the ordinary emotional turmoil of a teenager facing the end of a relationship. Michael Borden met with David for a conversation that lasted between 30 and 45 minutes, during which he told David directly and clearly that he was no longer permitted to see his daughter. And according to the account that investigators would later piece together from witness statements and from David's own confession to police, David stood there for several minutes after being given this information, staring into space, apparently processing what he had been told, and it was in those minutes, according to his own account to law enforcement, that he made the decision to kill the couple, a decision that was made in that moment, in that room, in response to a parent telling him that a romantic relationship he was not legally entitled to pursue in the first place was over. David drew the pistol he had brought with him and shot Michael Borden in the head. He then shot Catherine Borden in the head. And then he walked out of the house where two people lay dying, and Kara Borden, who had witnessed the murders of her own parents, got into a car with David Ludwig, and the two of them drove away, heading west, carrying between them the weight of what had just happened in that house, a weight that Kara, who investigators concluded had no knowledge of any plan and had played no role in the shootings, would spend the rest of her life carrying in ways that no one on the outside can fully imagine. Federal authorities located the two teenagers approximately 28 hours later following a car chase in Indiana that ended when David crashed the vehicle into a tree, and both were taken into custody without physical injury. Kara Borden was ultimately not charged with any crime, as investigators concluded that she had joined Ludwig voluntarily but had had no advanced knowledge of or involvement in the plan to kill her parents. David Ludwig faced the full weight of the law, and in June of 2006, at the age of 19, he appeared in Lancaster County Court and entered a guilty plea to 2 counts of first-degree murder, statutory sexual assault, and related charges. A plea agreement that spared him from the death penalty that prosecutors had been seeking, and that resulted in a sentence of 2 consecutive life terms plus 9.5 to 19 additional years in state prison, along with an order to pay $125,000 in restitution. A sentence that means David Ludwig will spend the remainder of his natural life behind bars, a consequence he was warned of in terms of considerable moral force by Judge David Ashworth, who told him at sentencing that by his useless and selfish acts he had destroyed and permanently altered the lives of countless people, and who noted that the Borden family had asked that David not even be permitted to apologize in the courtroom because they thought, in the words of the district attorney, that it was a bit too late for any sort of apology, a sentiment that captures something essential about the nature of what David Ludwig took from that family on the morning of November 13, 2005. Not simply 2 lives, but the sense of security, the sense of trust, and the sense that the ordinary exercises of parental love and protective authority that Michael and Catherine Borden had been engaged in on that morning were reasonable and safe things to do. Number 6. Sef Gonzales, the baby-faced killer of North Ryde. There are crimes that are defined not only by their violence, but by the elaborate architecture of deception that surrounds them. Crimes in which the person responsible invests extraordinary effort in constructing an alternative explanation, a false narrative, a performance of grief and horror designed to redirect suspicion away from themselves and toward a story that serves their interests. In the case of Joseph Claridades Gonzales, known throughout the Australian true crime community and beyond simply as Sef Gonzales, is perhaps one of the most carefully constructed examples of this kind of deception in modern criminal history. A case in which a 20-year-old man murdered his entire immediate family in their suburban Sydney home on an afternoon in July 2001, and then spent the following months performing grief with such apparent conviction that it took investigators an extended period of patient and methodical work to assemble the evidence that would eventually bring him to justice, evidence that, once assembled, told a story of premeditation, of financial motivation, of resentment, and of a fundamental coldness of character that the victims, his own father, his own mother, and his own teenage sister, never had the opportunity to perceive clearly before it was too late. Sef Gonzales was born in 1980 in Baguio, in the Philippines, and came to Australia as a child with his family. His father Teodoro, known as Teddy, a trained lawyer who had built a successful legal practice in Sydney. His mother Mary Loiva Josephine, known as Loiva, who was 43 years old at the time of her death, and his younger sister Claudine, who was 18 years old and had just celebrated her birthday the day before she was killed, a detail of devastating timing that has stayed with everyone who has followed this case in the years since. The Gonzales family had built a comfortable and prosperous life in North Ryde, a suburb of Sydney, accumulating an estate that was valued at approximately $10 million. A fortune built through Teddy's legal practice and through the disciplined financial management of a family that had immigrated with ambition and determination and had succeeded by the standards of any measure. And it was this estate, this inherited fortune that Sef stood to receive upon the deaths of his parents, that investigators would eventually identify as a central element of his motive for the killings, alongside a second motive rooted in his academic failures and his parents' response to them. By 2001, Sef Gonzales was enrolled at Macquarie University, but was failing badly, concealing his academic failure from his parents the way that Sidney Powell would conceal hers nearly 2 decades later, forging academic results to maintain the appearance of a student making satisfactory progress, while in reality falling further and further behind. And his parents, Teddy in particular, had high expectations for their son, expectations rooted in the values of education, achievement, and professional success that had defined their own immigrant journey. And when Sef's deceptions were discovered or threatened to be discovered, the consequences within the household became a source of significant tension that was compounded by a romantic relationship Sef had been pursuing that his mother disapproved of, and that had created additional friction in the family dynamic. On the afternoon of July 10, 2001, Sef Gonzales returned to the family home in North Ryde at approximately 4 in the afternoon, while his father was still away and while his sister Claudine was alone in her bedroom, a day after her 18th birthday. And what happened in the hours that followed in that house? The sequence of events that Sef carried out with what forensic evidence and circumstantial reconstruction would later suggest was a deliberate and premeditated plan, resulted in the deaths of all 3 members of his immediate family by the time his father Teddy came home and was also killed. And when investigators arrived at the scene, they found Sef Gonzales outside the home in a state of apparent distress, having called 000 with a frantic account of having discovered his family in pools of blood upon returning home. And they found inside the house something else as well. Spray painted on the wall of the living room, in large letters, were the words referring to a racist hate group and an anti-Asian slur, a staged piece of evidence intended to direct investigators toward a narrative of racially motivated violence carried out by unknown intruders, a fabrication so calculated and so cold that it speaks to the depth of premeditation behind everything that Sef Gonzales did on that afternoon. Investigators, however, were not persuaded. The physical evidence was inconsistent with the intruder narrative in ways that became more apparent as the investigation developed. The amount of blood on Sef's clothing at the scene was minimal given what should have been his proximity to the victims if he had in fact discovered them immediately upon arriving home. His accounts of attempting to resuscitate his family did not align with the physical evidence at the scene, and a series of additional inconsistencies in his account, combined with the identification through forensic analysis of evidence connecting him to the crime, led investigators to arrest Sef Gonzales on June 13, 2002, nearly a year after the murders, by which point he had spent months performing the role of a grieving son in public, attending memorial events, speaking to media, and maintaining the fiction of his innocence with what those around him described as a composure that, in retrospect, speaks to the depth of his disconnection from any genuine remorse. The trial in the New South Wales Supreme Court took place in 2004, with the prosecution led by Crown Barrister Mark Tedeschi presenting a case built on forensic evidence, on the inconsistencies in Sef's accounts, on evidence of his academic deceptions and the financial motive they supported, and on the systematic dismantling of the racist intruder narrative he had constructed. And on May 20, 2004, the jury found Sef Gonzales guilty on 3 counts of murder, guilty for the killing of his father Teddy, guilty for the killing of his mother Loiva, and guilty for the killing of his sister Claudine, who had been the first to die that afternoon, attacked in her own bedroom on the day after her 18th birthday by the brother she had grown up beside. On September 17, 2004, Justice Robert Ellis sentenced Sef Gonzales to 3 concurrent terms of life imprisonment without the possibility of parole, citing in his sentencing remarks the premeditated nature of the killings, Sef's complete absence of remorse, and the profound betrayal of familial trust that the crimes represented. And Sef Gonzales has remained incarcerated in the New South Wales prison system ever since, having pursued multiple appeals over the years, none of which have succeeded. While the house in North Ryde where his family died was eventually sold, its history required to be disclosed under a law that the New South Wales government passed specifically in response to this case, a law that stands as one of the more unusual legislative legacies of a crime that not only took 3 lives but changed, in a small but permanent way, the legal landscape of property transactions in New South Wales, ensuring that the house where Teddy, Loiva, and Claudine Gonzales spent their last hours would never again be sold to someone unaware of what happened within its walls. Number 7. Darren Huneman, the Shakespeare reading mastermind. There are criminal cases in which the perpetrator is distinguished not by impulse or passion, but by something far colder and far more calculated. A capacity for long-term planning, for the manipulation of others, for the construction of a scheme designed to achieve a specific financial outcome, while keeping the perpetrator's own hands free of direct involvement. In the case of Darren Huneman, a teenager from Saanich, British Columbia, who in 1990 orchestrated the murders of his mother and grandmother for a $4 million inheritance, is one of the most striking examples of this category of crime in Canadian criminal history. A case that combined the precocious academic intelligence of a young man who was known to his teachers and peers as exceptionally bright, a reader of Shakespeare and a student of history, with a moral emptiness so complete that he was capable of inviting 2 of his classmates to a Thanksgiving dinner and using that invitation as the mechanism for a double murder he had planned with the deliberateness of someone who had thought through every detail except, ultimately, the loyalty of the people he had chosen to carry it out. Darren Huneman was 18 years old in October of 1990, a student at Mount Douglas Secondary School in Saanich, British Columbia, and he lived in a world shaped significantly by money. His grandmother, Doris Leatherbarrow, was 69 years old and had built a successful clothing chain business that had generated a fortune estimated at approximately $4 million, and his mother, Sharon Huneman, was 47 years old and stood to inherit that fortune, which would in turn pass to Darren upon her death, making him the ultimate beneficiary of an estate that represented a level of financial security and independence that he had apparently decided he was unwilling to wait for through natural means. The timeline of when exactly Darren began to formulate a plan to accelerate this inheritance is not entirely clear from the public record. But what is clear is that by October of 1990, he had recruited 2 of his Mount Douglas Secondary School classmates, Derek Lord, 17 years old, and David Muir, 16 years old, and had persuaded them, through a combination of financial promises and whatever personal authority or social leverage Darren exercised within the peer relationships of that group of teenagers, to carry out the murders of Sharon Huneman and Doris Leatherbarrow in exchange for a share of the inheritance that the killings would generate. The plan was executed on a day when Sharon and Doris had invited the boys to what they understood to be a social visit at Doris Leatherbarrow's home in Tawasin. The women welcomed Lord and Muir into their home, into the domestic safety of a space they shared with family and with people they trusted, and Lord and Muir used that welcome to carry out the attack that Darren Huneman had planned, beating both women with a blunt object, stabbing them repeatedly in the throat, and leaving them to die in the kitchen of the home where they had been preparing to share a meal, while Darren Huneman himself was elsewhere, establishing an alibi, his own hands entirely uninvolved in the physical act of violence, while the 2 teenagers he had recruited did what he had persuaded them to do. The bodies of Sharon Huneman and Doris Leatherbarrow were discovered, and the subsequent investigation moved with a focus that eventually landed on the 3 teenagers. David Muir, who ultimately confessed to his role in the killings, became the cooperative witness whose account gave investigators the detail and context they needed to build the full picture of the plot, and all 3, Darren Huneman, Derek Lord, and David Muir, were convicted of first-degree murder in 1992 and sentenced to life imprisonment, with Lord and Muir receiving life sentences with no chance of parole for 10 years, reflecting their status as young offenders at the time of the crime, and Darren Huneman receiving a significantly harsher condition, life imprisonment with no chance of parole for 25 years, reflecting the court's assessment that as the architect and instigator of the entire scheme, he bore the greatest degree of criminal responsibility. In the years since, the three men's experiences of the parole system have followed different paths. David Muir, who confessed and cooperated, was granted full parole in 2003 after serving 10 years. Derek Lord, who has maintained his innocence throughout, has had a more complicated relationship with the parole system, at various points being denied and eventually being granted full parole in 2024. Darren Huneman, who changed his legal name to Darren Goen, the surname of his biological father, has also navigated a lengthy parole process, being denied his first application after 25 years and eventually being granted day parole in August of 2022, which has been extended at regular intervals. With Huneman now living in a community residential facility under day parole conditions, as the Parole Board of Canada has gradually and cautiously expanded his community access. A process that the surviving family of Sharon Huneman and Doris Leatherbarrow has followed with pain and vigilance, appearing at hearings, reading victim impact statements, and ensuring that the parole board understands, in the most direct and human terms possible, the weight of what was lost in that kitchen in Tawasin in October of 1990, when two women who had opened their home and welcome were killed by the plan of a boy who had decided that their lives were worth less than the inheritance he would collect upon their deaths. Number 8. Derek and Alex King, the youngest killers in Florida history. There are criminal cases that force society to confront the very edges of its understanding of childhood. Cases where the ages of the perpetrators are so young and the crimes so serious that every comfortable assumption about innocence and culpability and the capacity of a child to truly understand what they are doing collides with the undeniable reality of what has occurred. In the case of Derek and Alex King, who were 13 and 12 years old respectively when they beat their father to death with an aluminum baseball bat in their cantonment, Florida, home on the night of November 26, 2001, is one of the most extreme and most discussed examples of this kind of case in modern American legal history, a case that became not only a criminal proceeding but a national conversation about juvenile justice, about the prosecution of children as adults, about the influence of predatory adults on vulnerable young minds, and about the extraordinarily complicated question of what justice looks like when the people who have committed a serious crime are barely old enough to be in middle school. Terry Lee King was 40 years old in November of 2001, a single father raising his two sons Derek and Alex in a home in Cantonment, Florida, a small community near Pensacola. And while the portrait of family life in that household is complicated by the accounts that emerged during the legal proceedings that followed, accounts that touched on the boys' relationship with their father, on the presence in their lives of a man named Ricky Chavez, and on the circumstances that had led Derek and Alex to spend a period of time away from their father's home immediately before the night of the killings. What is not complicated is the bare fact of what happened on the night of November 26, 2001, when Terry King was sitting in a recliner in his living room, and his two young sons came to him, and Derek, the older of the two at 13 years old, beat his father to death with an aluminum baseball bat, while his 12-year-old brother Alex was present, an act that was followed by the deliberate setting of a fire inside the family's home. Flames lit in the bedroom before the boys fled, in an attempt to conceal what had been done and to create the appearance that the cause of Terry King's death might be the fire rather than the violence that had preceded it. The boys did not go to a neighbor, did not call emergency services in panic, did not do any of the things that a child in genuine distress might be expected to do. Instead, they called Ricky Chavez, a 40-year-old family acquaintance who had become deeply involved in the lives of the King boys, particularly in the life of 12-year-old Alex, a man who would later be charged with child molestation in connection with his relationship with Alex. And Chavez came and collected the boys, took them to his home, washed their clothes to remove any blood evidence, and hid them under a trap door in his home when Terry King came looking for his sons after they had been missing. A sequence of events that placed Ricky Chavez at the center of the case, and that generated enormous legal controversy about the degree to which Chavez had influenced, manipulated, or even directed what the boys had done. Firefighters responding to the report of a house fire discovered Terry King's body in the ruins of the burning home, his head wounds inconsistent with fire alone, and the investigation that followed quickly identified the two missing King boys as the primary subjects of inquiry, and when Chavez brought Derek and Alex to the sheriff's station the day after the killing, both boys gave statements to investigators that were at various points consistent with their own guilt and at other points pointed toward Chavez himself as the person responsible, a contradiction that would define the confusion at the heart of the legal proceedings that followed. Derek and Alex King became the youngest people ever to stand trial for murder in the state of Florida, tried as adults on charges of first-degree murder and arson, and the trials themselves were among the most unusual in Florida legal history. Ricky Chavez was tried simultaneously on charges of first-degree murder in a separate courtroom before a separate jury, and the two verdicts created an immediate and irreconcilable contradiction, because the jury in Chavez's trial acquitted him of murder, while the jury in the boys' trial found them guilty of second-degree murder, meaning that the legal system had simultaneously concluded that the boys had committed the murder and that the man who was tried for the same murder had not. A logical impossibility that the presiding judge found so troubling that he subsequently threw out the boys' second-degree murder convictions on the grounds that their right to due process had been violated, sending the case into mediation and ultimately resulting in a negotiated resolution in which Derek and Alex both pleaded guilty to third-degree murder and arson, with Derek receiving a sentence of 8 years in prison and Alex receiving 7 years, both to be served in separate juvenile correctional facilities. Sentences that reflected the profound difficulty of the legal situation and that have continued to generate debate about whether they were appropriate responses to what happened in cantonment on the night of November 26, 2001. Derek King served his full 8 years and was released at the age of 20, and both brothers attempted, in the years following their release, to build lives outside the shadow of what they had done as children. They appeared on the Today Show in 2011, spoke about their experiences and their plans to pursue education and productive lives, and expressed in those interviews the kind of reflective awareness of their crime and its consequences that their childhood statements to investigators had so conspicuously lacked. Alex King, however, struggled significantly in the years after his release, encountering legal difficulties including a 2005 escape charge while still in the juvenile corrections system and subsequent probation violations. And on April 23, 2024, Alex King died of a drug overdose, ending a life that had begun in extraordinary circumstances and had never fully escaped their gravity, while Derek King has maintained a lower public profile in the years since his release. The two brothers' stories, serving as a permanent reminder of the long and unpredictable aftermath of violence that begins in childhood and whose consequences, for everyone it touches, extend across an entire lifetime. Number 9. Colt Lundy, the stepfather who never saw it coming. There are crimes that emerge from the combination of adolescent impulsivity, susceptibility to peer pressure, and a profound inability to foresee the irreversible consequences of a violent decision. In the case of Colt Lundy, who was 15 years old in April of 2010 when he and his 12-year-old friend Paul Gingerich shot and killed Lundy's stepfather Philip Danner in their Cromwell, Indiana, home, is a case that sits squarely in this territory, a crime that was, by the accounts of the investigation and the legal proceedings, planned in the specific sense that the two boys had discussed it and had a stated intention behind it, but that was carried out by perpetrators so young that the entire case became a focal point for the national debate about juvenile justice, about the appropriateness of sentencing children as adults for serious crimes, and about the competing obligations of a legal system that must simultaneously hold individuals accountable for violence and recognize the developmental realities of the adolescent mind. Philip Danner was 49 years old in April of 2010, living in the small northern Indiana community of Cromwell in Kosciuszko County, and he was Colt Lundy's stepfather, a man who had become part of Colt's family through his relationship with Colt's mother and who occupied the domestic space of the household in the way that step-parents do, with all of the complications and negotiations of authority and relationship that blended family situations often involve. The accounts of what drove Colt Lundy to make the decision he made are rooted in what investigators and the court record describe as a perception of the life he was living as restrictive. A 15-year-old sensed that the rules and expectations of the household were constraints he was unwilling to continue living within, and the plan that emerged from this perception was, at its core, an escape plan. Colt and Paul would kill Philip Danner, and then they would leave, driving, or traveling to California or Arizona, where they imagined they could begin a different kind of life on their own terms. A fantasy that reflects with painful clarity the emotional and cognitive immaturity of the two boys who conceived it, neither of whom had any realistic understanding of what life outside a household with no adult support and no resources actually looked like. On the night of April 20th, 2010, Colt Lundy and Paul Gingerich carried out their plan. Philip Danner was shot 4 times inside the family's Cromwell home, once in the eye, once in the wrist, and twice in the chest. Wounds that were fatal, and that left a man who had gone to bed in his own home that evening dead at the hands of a teenager who had decided that killing him was preferable to navigating the ordinary difficulties of adolescent family life. The two boys were arrested, and both were charged as adults, a decision that generated immediate and sustained controversy, particularly in the case of Paul Gingerich, who at 12 years old became one of the youngest children in Indiana history to be tried as an adult for a serious violent crime, and whose case eventually led to the passage of a law in Indiana, informally named Paul's Law, that created alternative sentencing pathways for juveniles who commit serious crimes, a legislative legacy that speaks to the degree to which this case forced the Indiana legal system to examine the adequacy of its existing frameworks for handling situations of this nature. Both Colt Lundy and Paul Gingerich pleaded guilty to conspiracy to commit murder, and both were sentenced to 30 years in prison, with the final 5 years suspended for probation. Sentences that were handed down in a Kosciuszko Circuit Court proceeding where Judge Rex Reed acknowledged the profound difficulty of the question before him. What is justice in this type of case? Before accepting the plea agreement and imposing the sentences that prosecutors and defense attorneys had negotiated, Paul Gingerich, benefiting from Paul's Law, was resentenced and released after approximately 7 years in custody, and by 2017, he was living with his mother under electronic monitoring conditions. Colt Lundy served a longer portion of his sentence, and in October of 2018, at the age of 23, he appeared before Kosciuszko County Judge David Cates to request a sentence modification, telling the court that he had done everything available to him within the corrections system to better himself, completing apprenticeships, pursuing education, engaging in counseling, and that he believed he had reached the limits of what the Indiana Department of Corrections could offer him in terms of further rehabilitation, a claim supported by the director of Kosciuszko County Community Corrections and by his own attorney, and disputed in emotional terms by Philip Danner's daughter, who told the court that she had never heard Lundy apologize before that day, and that while the work he had done in prison was meaningful, it was simply what he was supposed to do and did not constitute grounds for early release from a sentence imposed for taking her father's life. Judge Cates ultimately allowed Lundy to finish his sentence on home detention beginning in March of 2019, followed by a period of probation, a resolution that concluded the formal legal chapter of a case that had begun when two boys made a decision in an Indiana home whose consequences, for Philip Danner's family, for their own families, and for both of them, none of them could have fully understood at the time. Number 10. Anthony Blummel. When a reunion became a conspiracy. There are stories within the landscape of true crime that are defined not by the simplicity of their motives, but by the extraordinary web of relationships, reconnections, and shared grievances that surround them. In the case of Anthony Blummel, known to his family and to those who followed this case as Tony, is a story in which the reunion of a young man with his biological mother, facilitated by the casual connective power of social media, became the seed of a conspiracy that ended in the deaths of two people who had devoted years of their lives to providing Tony and his brother with a stable, loving home. People whose only apparent failure, in the distorted moral accounting of the conspiracy that unfolded around them, was that they had tried to be good parents to a child who would eventually decide that they were obstacles rather than family. Roger and Melissa Blummel were residents of Valley Center, Kansas, a largely rural community north of Wichita, and they were described by everyone who knew them as pillars of their community. Roger as a man whose laugh could be heard across a room, a storyteller, a man of warmth and easy generosity. Melissa as a woman with a heart of gold, someone who showed up wherever help was needed, someone whose compassion for others was a defining characteristic of how she moved through the world. The Blummels had adopted Anthony and his younger brother Christopher when both boys were toddlers, raising them in Valley Center as their own children, providing them with the stability and care that adoption is designed to provide. And for years, the household functioned as an ordinary family household, with the ordinary negotiations of parenthood and adolescence, and the complicated emotional territory that adoptees and their adoptive families sometimes navigate as the child grows older and begins to ask questions about identity and origin that are entirely natural and entirely understandable. When Anthony Blumel was 18 years old, his relationship with Roger and Melissa had deteriorated to the point where they asked him to leave the family home. The specific circumstances of that deterioration are part of the case record, and it was in the period following his departure from the Blumel household that Anthony, through the searching and connecting function of Facebook, made contact with his biological mother, Kisha Schaberg, a 36-year-old woman who had not raised Anthony, and who had been living a life entirely separate from the one he had built with the Blumels. The reunion between Tony and Kisha was, by the accounts of those who have examined this case, initially one of genuine mutual relief and connection, a young man finding his birth mother, a woman reconnecting with the child she had given up, but it rapidly became something else entirely, something that would ultimately cost Roger and Melissa Blumel their lives. Tony and a friend named Braden Smith traveled to California to stay with Kisha, and the three of them spent a period of time together that court documents describe as marked by drug use and by the gradual development of a shared grievance toward the Blumels, a grievance that Kisha Schaberg nurtured and amplified, reportedly saying on multiple occasions during their travels back toward Kansas that the Blumels should be killed so that she, Tony, and Christopher could be reunited as a family. Logic so distorted and so self-serving that it speaks to the degree to which the relationships and motivations at the center of this case had moved far beyond anything recognizable as rational familial feeling. What Kisha Schaberg appeared to want was not simply a reunion with her sons. She was, according to the evidence, also angry that Christopher, who had remained with the Blumels, wanted nothing to do with her, and she blamed Roger and Melissa for this, as though the values and relationships that had developed in a household she had never been part of were somehow a wrong that had been done to her, and that needed to be addressed. The plan that emerged from these conversations resulted in the murders of Roger and Melissa Blumel. They were shot in their Valley Center home, crimes that investigators traced back to Tony Blumel, Kisha Schaberg, and a third individual named Andrew Ellington, who had also been recruited into the conspiracy. The subsequent investigation, focused in part on the fact that Tony Blumel was the last known person to see his adoptive parents alive, moved toward charges for all three participants. And in May of 2015, both Anthony Blumel and Kisha Schaberg entered pleas of no contest to capital murder and aggravated robbery charges in Sedgwick County District Court, relinquishing their right to appeal in exchange for prosecutors agreeing not to seek the death penalty. And in June of 2015, both were sentenced to life in prison without the possibility of parole, a sentence that means neither Anthony Blumel nor Kisha Schaberg will ever be released from custody, a sentence that was addressed in emotional terms by Christina Blumel, Anthony's aunt, who spoke directly to her nephew at the sentencing hearing and told him that he had chosen to murder his parents, that he had chosen his path, and that no one had done that for him, and that someday he might come to understand his choices, or he might never know. Words that carry within them not only the grief of a family that had lost two beloved members, but also the profound and unanswerable question of how a young man who was given a home, a family, and a future by two people who chose to love him could come to see the ending of their lives as a solution to anything at all.